is on for a motion to compel discovery brought by Mr. Smiley's counsel, Ms. McLean. So I see that Ms. McLean is present, and I'll ask if Ms. Smiley, are you on the line today, Ms. Smiley?
I am here.
Okay, great. Welcome. All right. So I've read over the pleadings filed by Ms. McLean, and I'll just double check with Ms. Smiley. Just one moment. Bear with me one moment. All right. It looks like I'll just double check with Ms. Smiley. Did you receive a copy of the information that Ms. McLean filed related to the motion to compel discovery?
Yes.
And did you file anything in response?
I have not yet.
Okay. All right. Oh, I missed that last part. Could you repeat that?
But I'm finishing it up.
Okay. I think you said you're figuring it out.
No, I'm finishing it up.
Okay. All right. Well, today's the date that was set for the hearing, so I'm prepared to hear from Ms. McLean and move forward today. Ms. McLean.
Thank you very much, Your Honor. On behalf of the respondent, Robert Smiley, we are here on my client's request to compel discovery. As you can see from the documentation, the original discovery request was served on Ms. Smiley's former counsel back on September 12th of 2022. Counsel and I participated in a CR26I meeting, on November 7th, and it was agreed that completed discovery answers would be produced no later than November 22. Unfortunately, they were not complete. I'm missing bank statements from 2021, and the parties separated on February of 2021. I'm missing verification of the cost Ms. Smiley pays to cover the children on health insurance, which is pertinent to child support issues before the court. And we've also requested the past 7 years of her employee files, as she has lost multiple jobs, and my client believes that that may be due to underlying drug issues. Those are all documents and information that are completely within her control. I have made multiple requests to counsel prior to his withdrawal, asking for the follow-up and provision of all of those requested documents, and I've received nothing. And so we're properly before this court. We're asking the court to require Ms. Smiley to produce those documents to my office no later than May 3rd by 12 noon, and to schedule a review hearing on May 9 at 9 a.m. to review the sufficiency of her discovery answers. Also, we're asking the court to award my client $500 in attorney's fees for having to file this motion when clearly it's our position that she easily could have complied with the request.
Right, Ms. Smiley. Ms. Smiley, what's your perspective on the issue?
You know, I'm a single mom trying to work and take care of my children. Also, I have to pay everything out of pocket. Mr. Smiley does not. He's getting all of his lawyer's fees paid by the Cowlitz Indian tribe. So yes, I did lose my lawyer just simply because I cannot afford it any longer. And you know, none of my losing my jobs had to do with drugs, which is ridiculous. I've never had an issue with that. I guess know about how to get that information for Miss McLean. That's where I'm stuck, I guess, is.
What about the Red Canoe bank statements from January of 2021 to December of 2021? Isn't that something as simple as asking the bank, hey, can you get me printouts of those statements?
Yes, and I have them at home, and I was waiting to send everything in at the same time. I don't know how to go about getting it, you know, I know that sounds funny, but do I go to each job that I mean, there's 2 of them, and just ask for proof of why I was let go? That's where I'm stuck. I'm sorry.
That's definitely a start. I mean, certainly you can go to those folks and say, hey, I need records that shows that I was, employee files or verification or what have you. At least it's something. It's a start, and it's showing a good faith. Anything else you want to say about the motion to compel discovery?
I will get it in as soon as possible. I can go to those places today and ask for what she's asking for.
Okay. All right, thank you. Well, the system of discovery is basically, it's kind of on the honor system, is that each party is to share the information that they have and share information that the other party requests. And it may not necessarily be relevant, but it's something that in preparing for a case that there's broad discovery and we kind of err on the side of sharing. Here it looks like there was a completion. The request was made for the discovery back in September. There was what they call a CR26I conference that was held in November of last year. And then discovery was to be completed at the end of November. And apparently that hasn't happened. And then there's been some reminders that have happened also. So the motion to compel is well taken. There's grounds to grant it, so I will. So the deadline of the items that Mr. Smiley has requested through council, it will be due no later than May 3rd at noon. There's nothing that prevents you from providing that sooner, but that's the date that it's due. Okay. I'll set this to the docket on May 9th at 9 o'clock in the morning to just review the sufficiency of your responses. Because there has been, lawyers work, their time is what they give. Ms. McLean has indicated that she's expended quite a few follow-up requests and had to put together this motion, has to be here this morning to get this discovery going. Yep, so I will for Mr. Anagnostu's motion to withdraw from representing Ms. Fowler and also his related motion for fees. And then Ms. Cotto filed a motion related to communication. So let me touch base with Ms. Fowler. Ms. Fowler, did you receive a copy of Ms. Cotto's motion?
Your Honor, I did not. And I will also say that since I was represented, the court will not allow me to file anything until I am not represented.
Okay. Mr. Anagnostu, did you receive a copy of Ms. Cotto's motion?
Yes, I did, Your Honor. And we did forward that to our client via email.
Okay. All right. Very good. All right. So, Mr. Anagnostu, I have reviewed your motion to withdraw. I note that the court appointed you some time ago. And you've indicated that there's a conflict under several different, or at least two different rules of the rules of professional conduct. And anything else you want to add to your motion?
No, Your Honor.
All right. Ms. Fowler. Oh, go ahead.
I just had a comment with regards to my client's address. She's raising that as an issue. And pursuant to the rule 71, if when an attorney withdraws, if the client doesn't want their address disclosed, then documents can be served through the court. That's an option. But it's my understanding my client does not want to give her address out to Ms. Cotto.
And Ms. Cotto, do you have any objection to Mr. Anagnostu's motions?
No, Your Honor, I do not.
Okay. And Ms. Fowler, Mr. Anagnostu raised the issue of the address. Do you want to touch base on that, or do you want to state anything about that?
Yes, Your Honor. The reason is because I have filed all of Ms. Cotto's discovery requests habitually in the court proceedings, and she took my address information, sought out my landlord, and then represented her to evict me, which harmed her client as well because he's responsible for housing and, shelter, food, and basic needs for our child, which he hasn't seen her in 5 years. They've turned down every offer I've made to even see her. I've been trying to work this out. I've made multiple offers to work all these issues out. They've refused every single time and wasted so much taxpayer resources with crazy motions that I don't even know what to do. So I am afraid of giving her any updated information because she abuses it.
Okay. There's in the rules that Mr. Anagnostu referenced, which is Civil Rule 71C1, it says if the your address is omitted, the notice must contain a statement after the attorney withdraws. And so long as the address of the withdrawing attorney's client remains undisclosed and no new attorney is substituted, the client may be served by leaving papers with the clerk of the court pursuant to Rule 5B1. So if you don't want that, your address to be known, then your other option is you can be served by people who can leave papers at the clerk's office, and they'd have to follow the rules under 5B1. And that means that there'd be kind of a duty or obligation upon you to check with some regularity with the court clerk for papers that have been filed. And because otherwise, if you don't, then you've been deemed to have been served. So that's one option that we can pursue if you're interested in doing that.
Your option, or Your Honor, I do have a confidential address with the Secretary of Treasury, and I am putting a notice to relocate with my children due to work. I'm moving to Minnesota. And so that's not really going to be an option because I'm not even going to be able to have proceedings in this court anymore. I'm a federal employee. I have to leave with my children. I have to go where they tell me to.
You said that you can't be involved in this proceedings because you're moving?
I'm saying that the proceedings are going to have to continue where the children and I are residing, because obviously there's no way that I'm going to be able to fly back to Cowlitz County and do proceedings when I'm working.
Well, that'll be a motion for a different day as far as any change of jurisdiction. So until that time, this court holds jurisdiction over the matter. So Mr. Adagnostu's motion is well taken. I'll allow him to withdraw. I've signed that order that Mr. Adagnostu provided, so he is withdrawn officially. And then also I signed off on the order on the motion for attorney fees for the $1,342.50 to be paid to Mr. Adagnostu. You made mention, Mr. Adagnostu, of possibly including additional fees for today, or did that include fees for today?
That did not include the fees for today. At this point, I would just like to have this matter kind of my involvement concluded, so I won't pursue additional fees.
Okay, I've signed off. On both those orders.
Your Honor.
Yes, then let's take up hear from Ms. Cotto.
Thank you, Your Honor. I think my affidavit or my information to the court pretty much spells out the problem I've got. Ms. Fowler continually abuses the email information, which I've basically outlined to the court as far as the midnight and late night numerous emails. So emails is not an option. I think that serving it to the clerk of the court may be the only option and I can tell the court that I think the court is aware of the ongoing issue with Ms. Fowler if the court reviewed the file. I didn't do anything unethical, but that's not before the court. I just need a very clear direction on where I can serve Ms. Fowler with documents, because we do have a motion to compel in a couple of weeks because I can't get discovery. That's been noted. I did serve Mr. Adagnostu. I can't serve Ms. Fowler by email because she's blocked.
Okay. All right. So let me touch base with Ms. Fowler. Ms. Fowler, first off, as far as how would you like to be served documents?
Your Honor, as I stated, for victims of domestic violence, the state has set up a confidential address system for court documents and stuff to be sent to. And I do have one of those because I am a victim of domestic violence. So I would request that the documents be sent through the Department of Treasury's confidential address system. And that is how I will be able to receive these documents. And then moving forward, I am filing a request of recusal of counsel and then a change of venue as well, due to the fact that I am relocating with my children, and I will file appropriate paperwork in regards to that matter as well.
Okay, thank you. Ms. Cotto, as far as the confidential address program, do you have?
I don't believe that that's accurate, and I don't believe that Ms. Fowler is actually part of that. We've got a lot of misinformation that's been given to the court. I would just ask that I be able to serve it on the clerk or give it to the clerk of the court. Ms. Fowler has a way of basically spinning things that I think are a misrepresentation. She hasn't provided any documentation to show that she's part of this witness protection, even though she's alleged it. She's also mentioning 2 children, which I'm only aware of 1. So I would just ask to be able to serve it on the clerk of the court. This situation has been brought about by Ms. Fowler continually harassing me, filing bar complaints against the 3 prior counsels. She's really kind of created the situation. So I think that it would be most appropriate that the court allow me to serve clerk of the court.
Okay, thank you. And Ms. Fowler, what indication in the court file do I have that you're part of the confidential address program?
Your Honor, at the beginning of my proceedings, when I was pro se, I was going through a domestic violence shelter, and I do believe that the information for that confidential address through the Department of Treasury was provided. As far as Ms. Cotto's allegations, they're rapidly false. There's no bar complaints against my previous counsel, and it is illegal for her to continue this course of action with me for making a bar complaint against her, because I did, and I did in good faith. And I have a lot of a compilation of the last over 4 years of her representation of why I did that. And it shouldn't be a matter before the court, nor in my family law case, other than for a motion to recuse. And that's not before the court today.
All right, so Ms. Feller, I'm looking through the case file, looking under confidential sealed documents, and I'm not seeing anything that purports to be an indication of involvement in an address confidentiality program. So without that in the court file, what can you point me to that shows me that you're involved in that program? Because we're talking about the issue of service, how you can be served with papers, which is super important, so you can be aware of what's happening in the case. So what can you point to me in the case file that shows that you're part of that program?
My domestic violence counselor was the one who did the majority of the assisting with paperwork when I began.
When do you think she filed that? When do you think she filed that?
That would have been done in the very beginning, but I will not waste court time today either, because I know that you guys have other pressing matters to attend to. So for temporary, I'm willing to accept papers through the court, but I will let the court know that it's going to be very hard for me to habitually call in to the court, because there's a lot of times I'm out of state. And I will do my best to make sure that I'm keeping up with the court, but I feel that it also it gives Ms. Cotto a way to file papers without me knowing.
Okay. All right. So as far as the address or where Ms. Fowler can be served documents, there's no indication in the case file that Ms. Fowler is part of the address confidentiality program. She's indicated that she's not willing to provide an address to Ms. Cotto. So there is a section as pointed out by Mr. Anagnostou that allows for service upon the court of the clerk. So that's where that will occur, and that will remain in effect. All service can be effectuated upon Ms. Fowler by serving the court clerk with those documents until further order of this court.
I can prepare an order and serve a proposed order on Ms. Fowler. We're actually going to be before the court on I believe in 2 weeks, and we can present it at that time if Ms. Fowler doesn't agree.
Okay. Then there is a related motion related to Ms. Fowler serving Ms. Cotto. There is a request, Ms. Fowler, that you serve Ms. Cotto either only by U.S. mail system or via email during working hours, Monday through Friday, 8:30 to 5:30, and only 2 times per day within a 24-hour period. Do you have any objections to that?
Excuse me, Your Honor. Excuse me, Your Honor. I'd like to modify that because there's been abuse since that was presented, and it was an ongoing issue. So I would just ask that I be served by USPS. We do have an old order for that, but I would like an ongoing order that I be served by USPS.
Okay. All right. So it sounds like the motion has been modified or reduced in scope. So Ms. Fowler, that Ms. Cotto is asking that if you serve her any documents, she's requesting that you serve her through the United States mail system. Do you have any concerns or objections to that?
I have no objection to that, other than generally I have a process server serve paperwork to her office. That way that there's a process server that can make witness to the service, because previously I sent things through certified mail and I had issues with them locking the doors, and I have full documentation of that. So generally I have a process server or send things through US mail.
Okay. All right. All right. So it sounds like there's no objection on Ms. Fowler's behalf that She uses only United States Postal Service to serve documents to Ms. Cotto, and that if she wants to hire a process server, she can obviously do that. So
Okay.
I'll grant the motion brought by Ms. Cotto. So on May 2nd, review proposed orders related to Ms. Cotto's motions today. So any further items on your end, Mr. Anagnosto?
No, Your Honor. Thank you.
Ms. Cotto, any further items on your end?
No, I don't believe so. Thank you.
And Ms. Fowler, any further items related to the motions today? Mr.
No,
Reed
Your
on
Honor,
the
thank you.
line, Representing.
All right, thanks,
there
all.
it is. Representing Erica Turner, good morning. And Mr. Hamir is on the line, representing Donovan Day, good morning.
Good morning, Your Honor.
And I'm not sure if Twyla Corey is on the line. She's the guardian ad litem. She may not be here. We're on today for, I believe, a presentation, and we have some different orders that were submitted by the parties. So let's just double check, make sure we're on the same page. So I have a proposed child support order that looks like it's been signed off by both parties. Any concerns if I were to sign off on that child support temporary order?
Your
We
Honor.
intended, go ahead. So go ahead, Ms. Looney.
Sorry, Your Honor, the state is involved on this case. I was unexpectedly ill yesterday. We'd requested an additional copy of the order with the signature line for the state. But if Your Honor could interlineate that we do approve, we did agree with the language inserted. We just didn't have a place to sign.
Yes, let me go ahead and add a line there.
Your Honor, if I may.
Yes,
just
go ahead.
We have, Mr. Reed and I have been talking once again for the last, and I'm sorry to do this, Your Honor. I know we've been here multiple times. We're trying to knock this out. Have everything agreed except one minor issue. And we're requesting, and I've spoken to Mr. Reed about it this morning. We're requesting one more week just to clear up the matter that we're trying to resolve. It was brought to our attention last night. I've spoken to Mr. Reed with it over the last 24 hours, and I believe he would agree that we're asking for a continuance just for 1 week. And I'm sorry to do this again.
And Your Honor, I think we're okay with going through the other documents. The only issue that we have is with the parenting plan.
Do you agree, Mr. Hamir?
That is correct, Your Honor.
Okay, so going back to Ms. Looney's concern as far as the child support, the temporary child support, she's indicated that if we would create a signature line for her, and then I put Casey Looney, State of Washington. Any other adjectives or descriptors you'd like me to include therein, Ms. Looney?
I can give my bar number if Your Honor needs that.
Ready.
49606.
And what would you like me to put on the signature line? Approved via Zoom or approved?
Approved via Zoom would work, Your Honor. Thank you.
I will do that. Approved via Zoom. Related to the other proposed orders that I have before me, the parenting plan and the guardian ad litem order, there's a request to set that over. Is that correct?
The guardian item order is fine. It's just the parenting plan. And the only issue we currently have is on transportation. So.
Okay. All right. And then I'll save the parenting plan for future use. We're taking a look at as far as a date to come back. Do you have a proposed or agreed date that it would be convenient for the both of you?
We don't need more than a few days, and my expectation is we'll probably get to an agreed order that we can submit prior to a hearing. But if what I'm hearing is the next available date is May 9th, if that's as early as we can get, then that'll be fine with us.
Yeah, we could do May 2nd or May 9th.
We can, is it possible to, I'm sorry.
I just want to confirm, Madam Clerk, she turned her head, and so I got worried that I shouldn't be saying something. Okay, May 2nd or 9th is fine. That's fine. Mr. Hamir, I cut you off. Sorry.
No, that's okay. That's fine. That'll work. Thank you, Your Honor.
All right. So,
Your Honor, do you
Yes,
have
sir.
a copy of the temporary family law order? I know we had exchanged that as well, and I don't know if you have that.
I have before me the guardian ad litem order, child support order, the parenting plan. Let me double check. I don't.
Okay.
So
Then we'll be bringing that the next time, I think.
thank you. All right, we'll allow Mr. Reed and Mr. Hamir to continue their relationship by talking a little bit more. And we'll set this over to May 2nd at 9 o'clock for a presentation.
Thank you.
And then a temporary Fuel, Mr. Fuel, I
Thank
see
you,
him.
Honor.
He's present. He's representing James Perkins. I'll ask if Tanya Skelton is on the line. Ms. Skelton, are you here today?
Yes, Your Honor.
All right, very good. Welcome to you. We're on today for, it looks like a temporary order, and I've been provided proposed orders that appear to have the signature of both parties, Mr. Perkins and Ms. Skelton, and I'll just double check with Mr. Fuel if that's the intent here, is that looks like it's your client's signature as opposed to your signature. Are you comfortable with that?
Yes, Your Honor, and I did want to bring up I had a conversation with Ms. Skelton yesterday, and if there seems to be a single dispute that is in the child support order. If the court would turn to, just real briefly, page 6, if I may, if the court has that in front of. Okay, so thank you. So as you can see, Your Honor, it was originally drafted that the daycare cost would be split 50-50. Upon review, Ms. Skelton crossed that out, put in the 100% to my client, 0 to her. And then, as you can see, that got crossed out again, and 50-50 got written back in. I had a chance to talk to Ms. Skelton yesterday and then confirm with my client. And so what I'd like the court to do, my client has changed his position to agree with Ms. Skelton that he will, in fact, pay 100% of the daycare costs as she was requesting. But that obviously I think if the court is willing to just maybe interlineate that and indicate that the court has done so, I think that will resolve these 3 orders. I did suggest that Ms. Skelton appear to give her input, and I know she's already acknowledged she's here, so I don't know if there's anything else that she wants to say about that, but we are okay with her requested 100% to my client.
Okay, thanks. Ms. Skelton, do you have any questions about what Mr. Fuel was just talking about the child support order where it's talking about daycare expenses?
No, if he's going to pay 100%, if he needs daycare, am I allowed to take him during that daycare time, or he's just going to put him in daycare and pay for daycare?
I'm not sure. As far as maybe we can just dissect this out a little bit. So just on the first issue of the payment of the daycare expenses, it says James pays 100% of daycare expenses for the child, and you pay 0% of the daycare expenses for the child.
No, I understand that.
And you're comfortable with that, correct?
Yeah, absolutely.
All right. So I've basically whited out everything that was there previous, the markings and the numbers, and I've just put 100% under James and 0% under Tanya.
Thank you.
So with that, then I'll sign off on the order of child support. And then the second question you had, Ms. Skelton, was related to basically what's commonly referred to as, maybe it's not right of first refusal, but your question is if he wants to place the child into daycare and you're available, it sounds like you wanted to be able to care for the child instead of daycare.
Yes, Your Honor. That's why I put him pay the 100%, because if I'm available, I'd like to watch my son.
Right. So that would touch upon probably a provision within the parenting plan. And I don't know if that's covered within the parenting plan. Mr. Field, do you have any idea on that?
I do. There's not, as Your Honor described, what we'd call a right of first refusal clause in there. The parties have had some difficulty with, despite the fact we've agreed to final orders, some difficulty in communication that I think sort of prevents that working in a functional way right now. And I guess at this point, I was sort of under the impression that we were in agreement on that parenting plan as is. So I am happy to, for whatever input I can give to Ms. Skelton, I'm happy to maybe follow up with some communication on that issue and talk to my client about it as well.
Okay. All right. So we'll do what we can today. As far as the child support order, I'm signing off on that. And I'm also signing off on the child support worksheets, which is kind of the foundational numbers that support the child support order. So I've signed off on both of those. As far as the parenting plan, it sounds like there's no provision within that parenting plan that addresses the issue that Ms. Skelton just raised related to taking care of the child. So I think that means that we'll probably have to hold off on signing off on the parenting plan and also hold off on signing the final order of family order.
Your Honor.
Yes, ma'am.
As far as the parenting plan not being signed over today, is there a way to get James to allow me to see my son? I haven't seen my son in over a month, And he's not allowing me any video chats with my son either.
So I'm not sure if there's an existing parenting plan. I think this is probably the first iteration of a parenting.
Yeah, unfortunately, there's no existing plan.
So under the proposed parenting plan that everybody signed off on indicates that the father is the custodial parent and that Ms. Skelton would have visitation on alternating weekends, Friday 6 to Sunday at 6. So that's kind of where we're at. So any motions related to parenting time or residential time that's not filed with the court, I'm going to decline politely to address that today. I'll allow the parties to talk offline if you'd like. You could probably come to some type of agreement, I would assume, related to that. I'm not sure. And then the parenting plan that I'm not sure if we want to set this for a hearing or if we want to allow the parties to discuss it and note it up at a later date. I'm inclined just to let the parties just note it up, and if the negotiations go well, then it'll be signed off on. If the negotiations don't go well, one party will probably be noting up, but I can be persuaded otherwise. Mr. Fuel.
Well, again, I was under the impression we had an agreement on those things. I'm actually just for the record, I know the court already signed the child support order, but I'm not sure necessarily that if we don't have an agreement on the parenting plan, that my client agrees to the support order.
Yeah.
But I think you're right. It sounds like perhaps we're a little bit farther off than I thought we were about a half an hour ago. And so I guess if just let us rather than set something for us to come back in, let's we'll see if we can crank it out, and if we can't, we'll cite it back in for something else, I guess. Well,
as far as the child support worksheets that I signed off on, do you want me to remove my signature at this point?
Yeah, I think it's probably best. I'll just let my client know that we didn't in fact have a deal, and we'll have to, I guess, maybe not go back to the drawing board, but hopefully hopefully we can cross the bridge smoothly.
Okay. All right.
Thank you.
All right. So, Ms. Skelton, just so you're aware what I'm doing, I was given proposed orders for the child support and the child support worksheets. It sounded like this is kind of a global resolution, including parenting plan. Without the parenting plan being finalized, I've removed my approval because it sounds like there's not approval from Mr. Fuel's client in that everything's not resolved at this point, and it's kind of a whole deal package. So I'll allow the parties to work on coming to an agreement, and if you can't, then either party could note it back up and the court will make a decision.
Great. Thank you, Your Honor.
All right.
Your Honor,
Yes, ma'am.
if there's no communication between me and Mr. Perkins, how are we going to come to an agreement? Mr. Perkins is not
Mr.
communicating.
Perkins is
anything with
represented.
anyone.
Mr. Perkins is represented by counsel, and that's who you would be speaking with.
So all communications have to go through his lawyer?
Yes.
Okay, what about, like I mentioned a little bit ago, visitations with my son?
Again, you would work through Mr. Fuel. He's the representative of Mr. Perkins.
Okay, am I allowed to have visitations with my son right now even without that parenting plan in place?
I'm making no ruling related to parenting or residential time. That's something that if the parties can come to some type of informal agreement, then more power to you. If you can't come to an informal agreement, then either party is free to bring a motion before the court asking for what they want. In your case, asking for parenting time. And if you can't come to an agreement, then the court will make a decision on that. 88-08. Okay. All right. They should have Ms. Bliss representing Ms. Mortensen. I see Mr. Zandy's camera's on. Representing.
Yeah.
Great. And then we should have Mr. Stephen Mortensen. Mr. Stephen Mortensen, are you on the line today?
I'm here.
Okay. All right. Very good. Welcome. Looks like there was a contempt order that was filed on January 10th of this year. Indicated there was a past spousal support owed of $6,900 plus a civil penalty and attorney fee of $750 and a credit card reimbursement of $915. And that we set this on to what's called a pay or appear docket every third Tuesday of the month. And that there was a show cause order served on Mr. Mortensen related to that review hearing. So I'll hear from Mr. Zandy first and then hear from Mr. Mortensen second, please.
And good morning, Your Honor. Can you hear me? I was having some microphone difficulties a few moments ago.
Yeah, you're coming through.
In any event, We are set for review. This is my understanding that Mr. Mortensen's to appear every third Tuesday of the month and review the status of his payments pursuant to various findings and contempts that have been made. Most recent information provided by our client indicates that Mr. Mortensen did pay $200 on Friday the 14th. Outside of that, we've gotten very little. Best of my knowledge, he's paid nothing towards the credit card as court ordered. He's paid nothing towards the IRS as court ordered. And again, this is a case where he's responsible for $1,500 per month in spousal support. It appears that he has the means and the resources to pay what the court has obligated of him. But to date, he's continues to have issues paying so in a complete and timely manner. No, this is now several times that Ms. Bliss has had to appear before the court, and we largely have ongoing non-compliance with this. Not sure where this puts us. Again, I do understand that it's been every third Tuesday of the month that he's been essentially required to appear. But at this point, my client is going backwards in what she would be getting for support and legal fees to be here once a month. So that's kind of the latest from our end. Does appear that he's present. I don't know what the justification is for only paying the 200, but again, that is pales in comparison to what is required of him under the order.
Thank you, Mr. Zanti. Mr. Mortensen, what's your perspective?
As far as the credit card payment, I've been told by the bank, which is the credit union, that I can't do anything on the card. I can make payments, but Ms. Mortensen is still using the card little bits and then putting back in. So I'm trying to get her name removed off the card, or something, so that I can have full control of the card and make the payments as needed. Are you still there?
I am.
Okay. Lost video for a minute. And as far as the rest of it, I've got a truck payment and phone payment, rent payment, and like that. And I'm struggling right now to keep up with everything that I've got. Mrs. Mortensen did receive all of the funding from selling the house, which was $168,000, I believe. And she has already spent that, as far as I know. And that was on a verbal agreement when we separated, that she would get that. And it's just, I've got to live too, and I'm paying what I can pay. It's just a struggle at this point.
So you paid $200 on April 14th. Is that accurate?
Yes, and I've paid at least $200 a month every month since like January.
Okay. And is that $200? Is that going towards the credit card, or is that going towards the attorney fees, past spousal support? How are you making that payment?
It's going into a bank account in her name, okay, with Chase Bank, and I'm just depositing $200.
Okay. And how much do you pay for your truck each month?
I pay $341.
How much do you pay for your phone?
$165, I believe.
And rent?
Rent is $800.
And how much do you pay each month in spousal support?
I just $200 a month is what I've been paying.
What's the court order?
15, I believe.
So the $200 kind of what I'm thinking is, back on January 10th, there's a court order that ordered you to pay roughly $8,000. And then there's on top of that, or before that, is the requirement to pay spousal support. So there's a court ordered you to pay something, but you're not paying that. There's two things the court's ordered you to pay. One is the spousal support. Two is the back child support, or back spousal maintenance, pardon me, that you're not paying. You're not even touching that. So what's your plan to pay what the court has ordered you to pay?
At this point, all I can do is try to work out a budget where I'm putting more per month in. There's no way I can pay $1,500 a month in spousal support. I don't know where that number came from, but
from the court.
Right. Yeah, and I don't know how Ms. Mortensen's attorney came up with that number, but there's no way I can pay $1,500 a month. That's not even within my means at this point.
Okay. Can you, are you in a position to increase the amount that you're paying each month?
I could, yes.
Okay. What do you think would be a reasonable amount?
I mean, 500, 600 maybe would be doable at this point. And then I'd like to get Ms. Mortensen taken off of the credit card account, and then I can start making the payments on that.
Yeah,
I'm not even sure.
Yeah, with that, you
Go
can talk to Ms. Bliss and make some arrangements. Possibly, at least the two of you can talk about that. I think any effort to show compliance with the court order, an increase of payment is better than nothing. So, what the court is looking for here is compliance with its orders. And if you feel that
Okay.
there's, so if the court is expecting that each month you'll be paying the court ordered spousal maintenance award plus the contempt order. So additional funds should be going to that also. So Mr. Zandy, are you asking for attorney fees for today?
Yeah, absolutely. And I would just point out that I'm always kind of incredulous to the argument of, well, I could pay 500 or 600. I think that's reasonable. But over the past 3 months, he's paid $200, which is roughly the equivalent of his phone bill. I mean, that's kind of the issue that we have with this. Court made pretty specific findings. We've been here several times, not me personally, but Ms. Bliss in our office has, and it's the same kind of go around. So I would just point out that the frustration from my client's perspective, Ms. Bliss's perspective, and now my perspective is when you get someone lamenting about how they don't have enough money, but they've got a truck payment and a phone payment, some of these other things, and say, well, I could pay $600. I just haven't been doing it. So again, I think that kind of flies in the face of reason. I know we don't typically like to throw people in jail, but I think Mr. Mortensen needs to come up with a very solid, identifiable plan to keep himself out, because it seems to me, after my review of the history, to be kind of somewhat of an epidemic with him.
Okay. And all right. So what I'd like to do, Mr. Mortensen, we're going to come back on the third Tuesday of next month, the third Tuesday. Let me just pull that up so I have my calendar, at 9 a.m. What I'd ask you to do, Mr. Mortensen, is to submit something in writing to the court where it shows your budget and where you're making some cuts or reductions from one category and increasing that to the other category of the court orders. So we'll be looking to look at that very closely. So your plan to make payments satisfying the court order will be reviewed on that date. At this point, I will award attorney fees of $350 payable to Ms. Bliss's office. And then we'll see you on the 16th of May with your specific plan of reducing costs in one category and increasing costs or increasing payments to the court orders. And that we'll take a close look at that. I think I join the hesitation of Mr. Zandy as far as incarceration, but what I'm looking for is some serious budgeting analysis of what is necessary and what you can do to get by without to comply with the court's order. So we'll see you on that date with that written plan. Mr. Fuel is here representing Thomas Pedersen, Ms. Baldwin. Ms. Baldwin, I see that he is here also. Ms. Pedersen is here. Welcome. Ms. Height is here, and we're on for presentation. So it's kind of the second go around of presentation. I shared some thoughts from the first go. There's some objections that have been filed by Mr. Fuel. And so I think we should just kind of go look at those one by one and see where everybody stands. So bear with me one moment. Last time I indicated that on page 2, paragraph 4, the 8 hours should be 12 hours. I think that there was no concerns related to that. And then there was a request under page 2, paragraph 4, subsection 2, to strike on line 1314. The language that starts with, given this is a temporary order, counseling shall continue until terminated by the court. That was requested to be stricken. Ms. Baldwin?
So I think that's appropriate. The court did, I think through the GAL's recommendation that was what he needed to do. It shouldn't be sort of a one and done situation. If he's going to terminate counseling, that should be either by agreement that everybody's acknowledges he's reached his treatment goal, or with court review.
Okay, thank you. Mr. Fuel?
Thank you, Your Honor. Our position was simply that it should be between the counselor and my client, rather than having us all have to come back to court if there's a dispute.
Ms. Height?
Your Honor, I agree that this can be decided between Mr. Peterson and his counselor.
Okay. All right, I'm going to strike the language. So it'll indicate this. Line subsection 2 will read engage in personal counseling with an emphasis on respecting boundaries as directed by the counselor. And I've stricken the rest of the language. I think that's appropriate. It feels odd to me that I'm the one that telling the counselor when they're done. I think the counselor should be in the position to determine when the counseling is completed. Then taking a look at the next provision. That was on page 2. Next is on page 2, section 4.2, line 16. There's a request there to delete the word "and compliance." Mr. Fuel.
Yeah, Your Honor, obviously it's important that everyone have the information that my client is attending and participating. That's fine. Compliance, I feel like, gets into a little bit too much of the some of the privilege stuff that might be involved in some counseling. Again, I don't know for sure that that's necessarily implied or indicated by the phraseology of "and compliance." And so maybe if the court wants to massage that language, I'm just concerned that that turns into a little bit more information than just simply that my client is showing up as appropriate.
Okay, I'm going to leave that word in. I think that's appropriate to include that.
And I can report to the court, Olivia Lovely's office issues like a single page compliance sheet that just kind of tells you whether or not they're progressing in their treatment goal. So it's informative, but not that informative.
Yeah.
Thanks, counsel. Thank you. That's helpful information for me.
On page 3, section 4A, line 4, this is related to notification of healthcare appointments and the like. So I added my own language there. So this is what the order should read. Keep the first sentence, strike the second sentence, and then insert the language: petitioner must provide notice to respondent of all routine/standard healthcare appointments.
Do you ever have my amended order?
No.
Okay. So we said, no, that's okay. I amended that language to read, petitioner will give reasonable notice of any scheduled care.
That's fine. Yeah. Yeah. So I don't have that. That would be awesome. It would be a much cleaner copy.
Whatever it's worth, for the record, I have that. I have seen it.
Okay. And maybe what we could do as we're going through this, since I don't have that amended proposed order, that maybe a cleanup copy could be provided and we could sign off on it, and I'll just be much more presentable. Okay, great. We'll continue on. So I'm fine with that language that was proposed by Ms. Baldwin. Next is page 3, section 7B, line 23 and 25. To be a little more specific as far as the pickup times, Fridays noon or 2:30 as opposed to 6 p.m. and then the Wednesday 1:30 or when school is out instead of the 3:30. So I think the court indicated that it was. I'm not sure if I provided a specific time, so I'll turn to the parties for any recollection that you have.
I don't believe Your Honor orders specific time. The order generally is they pick up after school, and then there's a second sort of, but if there's no school, pick up at X. So we have for weekends, pick up after school or 6 p.m. if no school. Really, that's going to apply in the summer. So I sort of set that after work. And then Wednesdays, pick up after school or 3:30 if there's no school until 6 p.m. that same day, since that's a little bit of a shorter visit. Backing it up to times that really don't correlate to school at all doesn't make sense to me. The request is to back up Fridays to noon. School doesn't release at noon. If it's an early release day, you can pick them up because it's after school. So the proposed language doesn't make sense. It doesn't comport with school at all. It's not really related. I think this is just sort of an odd land grab.
Okay, Mr. Field.
Well, and we'd argue it's an appropriate land grab to use the metaphor. Obviously, if there's no school, and as the court recalls, the evidence before it was that my client is flexible with his schedule. So I appreciate that, everyone wants as much time as possible with the kids. My client would simply like his time, if there is no school, to start as soon as possible on the day of his parenting time. And I guess we would roughly, and again, I don't have the kids' school times memorized, but for my conversations with my client, the attempt was to roughly match noon with the daycare time that would be appropriate for picking up, and 2:30 to be approximately when school would have otherwise been out. So, but I do appreciate council's take there that it is sort of a bit of a made up time there. So we would just simply ask the court to consider as much time as possible, and maybe Ms. Height has some input on that.
I don't have a strong opinion on either one, Your Honor. I understand the issues, and I think the parties should work it out in the best interest of the kids.
Okay, great, thanks. I'm going to leave the language as proposed. I'm going to leave that there. Then we take a look at page 4, section 9, lines 11 through 13. There's a proposal to basically, if it's a long weekend, whether it's the 3rd or the 5th, it would attach to that weekend. If I gather your gist, Mr. Field, that's what
Yeah, and Your Honor, it's specifically for July 4th, and this year's a great example. I believe that this year the 4th is a Tuesday, and so effectively what my client is asking is that thereafter, if the weekend of July 4th happens to functionally create a 3 or 4 day weekend, that in between day be made part of the holiday, so a little bit less back and forth between, days off in between a weekend and the holiday.
Thank you, Ms. Baldwin.
The language that's being proposed will absolutely cause problems and confusion. If Your Honor wants to back it up and just say July 3rd from X time to July 5th at Y time, I have no objection to that. But this sort of chaotic, well, if there's a 4-day weekend and then we're trusting the parties to be able to figure that out, it's just going to result in the parties having a disagreement later. So if you want to back up the time, that's fine, but I don't want it to be reliant on a 4-day weekend.
Okay. Ms. Height, any strong opinion?
I agree with Ms. Baldwin on this one. I think that makes a lot more sense. It's cleaner and easier to use in the future for every week that comes up. The one thing that comes up typically on July 4th weekends, as Your Honor knows, is the fun doesn't really start until late in the evening, usually on the 4th. And so it makes sense for the kids to be staying over on the 5th, since they're going to get to bed late, typically that night. So that would be my only input on that.
Okay, thanks. There's a lot of information to remember with parenting plans. There's a lot of details, a lot of minutia. So the easier I think we can make it for everybody, the better. So I'm going to back it up a little bit for the 4th of July, and just changing the language from July 4th at 9 a.m. to July 3rd at 6 p.m. in both instances. So that allows additional time for the holiday, but it provides just a clear detail.
And just to clarify, Your Honor, were you indicating the return would be the 5th at 6 also?
No, the 5th at noon still. He just changed the start.
Okay, thank you.
Yeah, just the start time, correct. Thank you. And then
thank you, Ms. Baldwin.
Yeah, thanks. And then page 4, section 9, 16 through 21, this is winter break.
And I didn't have an objection. I did make that change.
Good. I didn't have objection to that either, so I made that change on my copy, but my copy doesn't really matter at this point. And then we'll look at there it is, page 9 relates to the texting, basically, 13H3. So that's at the top of the page. So Mr. Fuel, any just brief comments on that, and Ms. Baldwin?
Yeah, Your Honor, I think that your order was that my client would be able to communicate with and initiate texts. I said the children, I guess it was really more with the older child, but as of the 1st of May. And so we were just hoping that language could be put in to this section, since it seemed to be about that same activity.
Okay, Ms. Baldwin?
Yeah, I don't have any objection. I guess I'm re-looking at my language. It's not clear that father can initiate as well. So I can just change that to either can initiate reasonable contact.
Under that H or subsection 3, it talks about calls. It makes mention of call at least on 4 occasions. Maybe there could be some language in there that indicates communication includes telephone calls, text messaging, just be a little more inclusive, because I think that was the intent.
Oh, sure.
Ms. Height?
I agree, Your Honor.
Okay. All right.
I don't want it to be in section 3 because you specifically, those are obligations of my client. So section 3 puts an obligation on my client. So
Okay.
I don't want it to all of a sudden then lump that into the section 2 language that then my client's obligated to force the child to respond to every text. So, because then it can be read that way. So I would rather put language into section 2 that just is, that clarifies that father can initiate. And then in section 3, I don't mind being like calls or videos, but those are a different obligation than sort of can father initiate additional calls and texts.
So would you be comfortable if we just use the suggested language and move that to paragraph 2? That just
Yeah,
reads
that's
non.
fine. I don't mind. Yeah.
Okay, non-residential parent can communicate with and initiate text with the children.
Yep.
Okay, we'll include that in subsection 2, where it indicates any activities shall be posted to OFW. I'm disinclined to adopt that. I think both parties can contact the school and go to the websites and figure that out and get it. Just be proactive. And then, so I won't include that. On page 10, section 13K, there's a request to change it from 2 hours to 12 hours as far as the UAs based on work trips. For fuel.
Yeah, Your Honor, I don't anticipate this being maybe a practical issue at all, but there is a possibility. My client does just have a little bit of work travel that he does, and it's certainly possible that if and when the request comes at exactly the wrong time, this would be a practical impossibility. And so if the court is uninclined or disinclined to extend from 2 to 12, we're flexible on some other kind of language that allows him a little bit of breathing room in case it's practically impossible for him to actually take a test and get that done within the 2 hours as drafted.
Okay, thank you.
Our concern here is specifically the court's made a prohibition about alcohol, and there was concerns about alcohol. If you increase it to 12 hours, there's no ability for my client to test at all. Then he has the ability to essentially sober up and then be sober before going to get the UA. And so here, if there's some kind of limited work trip, I think that he would have to give, if the court was to add language, then I would say leave the 2 hours, but you can add in if he's on a work trip, he has to provide like immediate notice upon the request that, hey, I'm in Idaho. And that my client then has the option to find a testing facility in Idaho.
And isn't this provision really getting at the time that the father spends with the child? The idea is that we want all parents to be as clear-headed and present as possible. Excluding substances helps parents to be more clear-headed during their residential time. And so if he's on a work trip, while it may be concerning that he's drinking alcohol, it doesn't directly affect the children because they're not in his care. So in my mind, if we include language that if he's on a work trip and has no residential time, because it talks about that later on as far as timing of when when an alcohol test shows positive. I don't know. So I guess I'm struggling a little bit as far as how to craft that. I'm open to suggestions. Ms. Height, if you have any ideas, I'm happy to hear from you too.
Your Honor, I am in favor of having a UA done within the 2 hour limit because I think that gives us the clearest picture. I also agree that if he's on a work trip, he's not going to be having contact with the children. Furthermore, I know that in my past conversations with Mr. Pedersen, he is very aware of making sure he stays within the boundaries that are laid out by the court. He wants to not violate those. So I can understand his concern of not being able to get someplace in 2 hours. I just don't think that that's a concern because of what you stated earlier. If he's out of town, he's not going to be around the kids. So I think leaving it as he needs to comply within 2 hours. I think that would cover the issue.
Maybe we could do this, the second line where it says failure to report within the allotted time shall be construed as a positive test unless respondent is on a verified business trip or something along those lines.
Yes, I think that would provide the safety that everybody's looking for.
Something maybe on a business trip and not engaged in or foreseeably engaged in residential time or something along those lines. So that allows for testing to be requested by the mother for the protection of the children, but allows him to carry on his business and without having to worry that he's going to get a positive test for not going.
That works.
Okay.
I think that makes sense, Your Honor. Thank you.
Okay. Then the next section is please add there will not be any reimbursement for any cannabis related positive tests.
Yeah, Your Honor, that was that came out of your mouth at the hearing. Obviously, again, the issue is the alcohol, because cannabis specifically stays in the system significantly longer. That's what Your Honor had said.
True.
I don't have a recollection either way, and the clerk's minutes didn't reflect, so.
Yeah, if we could add that language, there will not be any reimbursement for any cannabis related positive test. I'm fine with that. Page 10 is a request to delete the language that starts, then that party's visitation shall be immediately suspended until further order of the court.
And so I amended this language to say that the party's visitation may immediately be addressed before the court on a shortened time basis.
And that addresses our concern, Your Honor. Thank you. Thank you, counsel.
Ms. Height, you comfortable with that?
Yes, Your Honor.
Okay, great. Thank you. And then page 10, section 13, L as in Larry, line 20. Also, this should say quote before or quote prior to having the children other than within.
I did change it to 8 hours. I don't think the word before makes a proper sentence.
Yeah, prior to.
I think you're probably right. Prior to, obviously, I think it's a little bit more precise. Obviously, the concern of within is that's a significantly different sort of concept than prior to.
Yeah, what do you think about the phrasing? Respondent shall not consume alcohol, non-prescribed drugs prior to.
I think it
or 8 hours prior to.
Yeah, if you put the prior to after, then my grammar is satisfied.
Our English teachers would be so proud.
Yeah.
It only took 4 of us.
Yeah, right. Right. Okay, so those are the ones that I had that were raised in the objections. Are there any others that we need to look at, or is that kind of Ms.
No,
Baldwin?
Your Honor. Thank you. I know that was an exhaustive list. I appreciate the court going through that.
Yeah, thank you. And then Ms. Baldwin, you'll produce that and.
Yes, I don't think we need another date though. I'll just produce that and circulate it to Ms. Height and Mr. Fuel.
That's fine.
Ms. Height, any other issues on your end?
No, Your Honor, I think that's it. Thank you.
Great. Mr. Gavino and Mr. Gandy is representing Ms. Cook, both counsel are present, and Ms. Turnbull is present as the guardian ad litem. And we're here today on a guardian ad litem report and feedback from the parties. So I'll hear from, there was the petition filed by Mr. Zandy's, by
my client.
Baldwin's, yeah, Ms. Baldwin's client back in December to modify the parenting plan, and this kind of tied up with the parent or the guardian ad litem report. So I'll turn the time to Ms. Baldwin if you'd like to go first, or maybe we should hear from Ms. Turnbull. Everyone's read her report. If she wants to highlight any items, she'd be free to do so, and then we could hear from the attorneys. Ms. Turnbull.
Sure. I think it's pretty clear in the report. I did focus on the 3 issues that the court had requested for the interim report, being Ms. Cook's domestic violence history, the issue of the pornography, and the issue of the Adderall. And I kept it to those issues. And then in addition, I had some concerns about the possibility of Mr. Gavino's hair follicle analysis and the reports of his alcohol and marijuana and drug history that had come along with that I thought that we might need to bring up here as well. So those are the things that I focused on for this report.
Okay, very good. Great, thank you. All right, Ms. Baldwin.
Well, thank you. And again, for the record, I'm Chelsea Baldwin. I represent Mr. Gavino. He's the father of 10-year-old Jameson and 8-year-old Kyson. It is important that we keep in mind that this case does have a final parenting plan, and that this is a modification of that parenting plan based on my client's petition. And so we're really looking at what's happened since that parenting plan was entered in 2021 and looking forward. I think in this case, the respondent is really trying to drag in information that is 10 years old, 12 years old, information that is very old, to sort of deflect from what's really happened over the last 2 years. There's no denial regarding the domestic violence in the respondent's home. She's had 3 different live-in boyfriends since 2021. They each have some significant history. We have domestic violence protection orders that the respondent has sought. Those include the children. We have essentially 30, I think, pages in Exhibit B of sort of, here's the watch report, here's a police report, here's a domestic violence protection order request, here's an order. We have felony assaults involving these people. These are choices that have been made by her to involve these people in her children's life. And these are lives, and this has all happened in the last 2 years. And again, that really speaks to sort of chaos in that home and turmoil in that home. And I think that that's relevant when we look at these 2 children and what their needs are. Similarly, when you look at, again, that sort of chaotic environment, the children report not only fights between the respondent and these boyfriends, but also they report fights between themselves and the respondent, and not things that go beyond sort of the traditional squabble that sometimes parents and children will have, but the children were reporting that kind of negative atmosphere that, again, is sort of born of that chaotic environment. When we talk about the exposure of the children to pornography, again, that really comes from an environment where no one's minding the store. Although the respondent is desperate to blame my client, to the guardian ad litem, the very first line of the guardian ad litem's report on that section is Ms. Cook does not deny the incident with Landon. And similarly, other family members are like, yeah, Landon is the one that introduced these 2 young boys to pornography. So again, despite this really significant effort on the part of the respondent to blame my client, no one else sees it that way. The reality is that these children were exposed to things they never should have seen, deeply inappropriate. And again, the respondent tries to say, well, look at these archived pictures that I have from 2019 or when the children were infants, and those don't really have anything to do with what's going on now. My client says, I didn't even think about the children being exposed to pornography. He's put all the blockers on now. But again, those things happen. Children get exposed to violence and sexualization when no one is minding what's going on. No one is watching them. And that happens in homes that are chaotic. And that really reflects the respondent's home. Again, we have these in and out boyfriends. We have this domestic violence happening. We have changes of work schedules on her part. Again, when it comes to the guardian ad litem brings up my client's substance abuse. My client says, hey, those things did happen in the past. No one had concerns then. We entered a final parenting plan with no restrictions and no concerns reported. And there were no concerns reported by respondent until she's under the microscope. And then she says, oh, now I have these concerns. But they weren't concerns raised before, or even when this case started. It's really just now that she's sort of like, oh, well, maybe I'll lose. Let me sort of throw this on the wall and see what sticks. The statements that my client's been fired, there's for some kind of substance use, there's no foundation for those statements. Those statements are purely hearsay. They should not be considered. My client says, look, I do smoke marijuana now and again, but it's at this point a legal substance. If the court's like, I don't want you to do that anymore, my client would gladly stop. He says it's an occasional thing. It's not a frequent thing for him. So again, something that's a legal substance that my client says isn't common. But when we're thinking about abuse of medications, it's important to think about the children in this case. The respondent really talks out of both sides of her mouth when it comes to this. She blames my client, saying, well, he unilaterally stopped giving the child the medication or stopped the medication with the physician. But she also claims that she was the one that unilaterally stopped the medication before my client even knew that the child was on meds. She can't have it both ways. And so similarly, she says, well, I stopped the child's medications in October, but she continued to pick up Adderall for the child until the physician says there's too many red flags here that indicate abuse of the medication. And recall that the child of this case who was prescribed Adderall had a hair follicle that showed none in his system whatsoever. I think that everyone here, every learned counsel, every member of the bench would be extremely skeptical of somebody who said, oh, my child's on Adderall, but even though the physician's prescribing it, I'm just going to unilaterally stop it, but keep picking up the prescription. That makes no sense. The only way that that makes sense is if you're abusing those prescriptions in one way or another. If a child needs medications, he should get them. They shouldn't be diverted to other things and other people. So again, the child had no drugs in his system whatsoever, none of the Adderall for a period of at least 3 months. That really doesn't correlate to mom's story at all. And again, it was at this point the physician who has stopped those prescriptions, and we don't have a new evaluation that says that the children need these. The concern is that children in chaotic environments, if you live in chaos, it's pretty hard to focus. If you live in chaos, it's pretty hard to do your homework. If you live in chaos and don't go to bed until 2 a.m, you're probably not going to be very focused at school the next day. So children that live in those environments can exhibit those types of symptoms. And it's just simply because, again, they're living in chaos. They're doing the best they can when they're 8 and 10 years old. They don't have a lot of tools in their toolkit to sort of take care of themselves. I'll note that my client's faith was sort of brandished as a possible reason. My client says absolutely not. He's not baptized into a faith that would prevent him from giving medications. He would absolutely give medications if they're appropriate. And again, he went to the physician, and the physician is the one that ultimately chose to say, hey, we need to stop this medication until we have more information about what's really going on and what these children really need. So again, I think that that's inappropriate to use someone's potential faith in that manner. It's important to know that the underlying plan is a 50-50 plan. The mother, in this case, again, desperately tries to cast my client as uninvolved, but it doesn't make sense in a 50-50 plan. My client has 50% of the time. My client's been the one who's been setting all of the children's dental appointments for the last 2 years. He's gone to medical appointments. He says, look, it's been COVID for the last 3 years. So some of these medical appointments that I didn't go to, I wasn't informed of, or I didn't have the option to go because only one parent could go because it was COVID. So again, this idea that my client has been absentee just doesn't ring true with the evidence that's before the court. I'll note that one of the children of this case does have an eating disorder. So again, we have things that really reflect a chaotic environment. A child who's in a chaotic environment may choose to control one thing or another in their life as their sort of thing that they can grasp and thing that they can control. And that can result in things like eating disorders. So we have a young person who now is suffering physical effects of that eating disorder. And I think it's important to think about the two households and what household would support a child with those specific needs. My client does have stability. He's got a wife, he's got a home, he's got stable employment, he's not moving around, not changing job schedules. He's been actively involved in the children's life, taking care of them 50% of their residential time. And my client says really it's been significantly more than that as a result of work changes on the part of the respondent. If we flip that and look at the respondent's household, again, we've had 3 live-in boyfriends in 2 years. We've had those people have felonies, domestic violence protection orders, restraining orders. We have a prescription for one of the children that's gone on and off. And we have it being picked up, but then not being given to the child. We have conflict in that home, exposure to pornography in that. So when you're weighing these and looking at the two households and the needs of these children, the question is, what is the best interest of these children? And the best interest is stability. It's not somebody who just says, gee, I promise I'll be stable from here on out. I would be interested in seeking treatment, but not that I am in treatment, not that I've done treatment. Again, I think that those are concerns. My client is the stable household that can provide what these children need. And these children clearly desperately need some stability in their lives. So we're asking the court to place the children primarily in my client's home where they can get the stability that they need. Mom still should be have an active and important place in these children's lives, but likely not as the primary parent. And again, we currently have a 50-50 parenting plan. So it's a situation where the court is deciding, I think, either to leave the plan in place for now or to change that calculus to see if moving to my client's household will result in better outcomes for the children.
Thank you, Ms. Baldwin. Mr. Zandy?
Thank you, Your Honor. Again, I do represent the respondent, Madison Cook, in this. I think it's important to look at how we arrived to this position. This is now, by my count, about the 4th hearing we've heard since the first of the year related to adequate cause and temporary orders and GAL appointments and such. And initially, I think the court was somewhat struck by the very different renditions of facts from both parties. You specifically stated that we're going to enter an interim order that will refer it to a GAL, and we'll come back and have a review to help us kind of cycle through a lot of the back and forth and the complete swearing match of the parties between what was actually happening. We now are in the benefit where we have a thorough and comprehensive report from Ms. Turnbow. We have information related to the allegations. And at this point, it now becomes an evaluation of credibility. And I would certainly state, as I have before in prior hearings, that Mr. Gavino is showing absolutely none. Not only is credibility an issue, but so is accountability. And he's taken zero accountability for any of his actions or how any of these issues with the kids have parlayed into some of his what's going on in his home. We're going to look at, again, the major issues that we have. And the first one is related to the pornography situation. And again, I don't think we can detail this or depict it any more clear than what is in the GAL's report. My client has told you that although perhaps the kids were exposed by their 14-year-old relative, there was no molestation, there was no grooming, there was none of that. It was curious kids, not suggesting that's right or appropriate. She immediately acted on that, took steps and said this isn't going to happen again. What wasn't before you and what wasn't told, and again, as part of the findings of the GAL, is dad's input in all this. Not only does dad provide the iPad for the kids years ago, that's never been resolved. Not only was dad soliciting prostitutes on that with open tabs the kids could readily access, not only was dad having conversations with other women about very sexually graphic communications, again, that the kids could easily obtain, but now post parenting plan, now we have dad with the same type of actions with this Kindle. My client had no idea about this Kindle. My client had no idea that dad and new wife were letting these kids have this Kindle and that they were viewing porn directly in mom and stepmom and dad's purview. It's concerning that dad points the finger at the 14-year-old and says, well, it's because of him and he showed my kids pornography and therefore we need to eliminate him and we need to modify the parenting plan because of that, because Madison didn't do anything. When the reality is anything but that. Dad was a major contributor to this issue. And again, that's borne out and that's part of the findings of the GAO. And again, that gets to the credibility. It's very concerning when dad has these messages, not only about the drug abuse, I'll get there in a moment, but about this pornography and again, the impact on these kids from Landon, but fails to assume any responsibility with that. To the point of having his kids, sounds to me like across the room or inside the same home, viewing this on a Kindle, and he is completely oblivious to that. That's problematic. Also, the criminal element of that. And I would ask the court to consider which is more harmful in kids being curious and explorative with one another. And again, it doesn't make it right, but that's the reality. Or those same kids going on dad's device and seeing messages to prostitutes down to how much is it going to cost to meet me at a hotel in Longview. Those types of things, again, are extremely detrimental to the well-being of these kids. It's very concerning to my client and I that Mr. Gavino, again, takes no accountability for that. Doesn't mention that, doesn't reference that, say, well, I probably should have put some parental controls on it. But oh, by the way, it's all Landon's fault as a 14-year-old who's in this. My client details for you, the GAL finds that although sure, Landon may have, and we still don't have any real resolution to that about what actually occurred. Landon may have showed these kids pornography, but again, there was no evidence that the kids had been harmed outside of seeing adult material. And again, what's been the theme of this all along? It's been Mr. Gavino who's constantly lodging things, and counsel used the analogy of throw what you can at the wall and see what sticks. This is the first example of that. Second example of this is this whole domestic violence issue. And again, this is something that's come under discussion for a while. I think it's interesting when you look at the two diametrically opposed declarations. My client details for you, she was honest with the GAO, she was honest with the court in prior declaration, and she's honest with the court in this declaration saying, yeah, and I think her term was, I have a broken picker, I need to get better at that. What's she doing to actually improve that and fix that? Well, first of all, she's acknowledging the problem. Second of all, she's seeking counseling. And third of all, which somewhat struck me, Ms. Turnbull suggested 6 months without exposing the kids to any new romantic partners. And my client says, I'm happy with that. In fact, I would be agreeable to 9 months without exposing the kids because I need to fix myself. Again, what's the other side of that story? Mr. Gavino, once again, has no input, no accountability, no acknowledgement of his domestic violence past with my client, who my client tells you was that was probably the most significant relation she had, exposing herself and the kids to domestic violence, but also currently what's happening in his situation. The GAL makes pretty specific findings. GAL has pretty specific examples of Mr. Gavino with his current wife, with one of the kids observing dad act out violently against the wife, and with the wife's own comments where she says, well, again, kind of downplays it, but says, well, yeah, to the counselor, there's this discussion about, and there might have been the kids might have been exposed to some of that between, Mr. Gavino and Miss Cook at the end of the relationship. Kind of alluding to the fact that that is still a prominent issue. And what do you get from Mr. Gavino? Again, he sticks to his guns despite the findings, despite the information that we've already provided this court related to his domestic violence history of breaking into apartments, overturning furniture, assaulting her in front of the kids and the like. And he downplays it. He just doesn't acknowledge it, again, because that doesn't fit his narrative of where he wants the court to know. That's concerning. If we look at the drug abuse and the substance abuse, and again, this one, I think is prominent and stood out to me. There was no findings of this Adderall issue. And again, that was one of the prominent themes that was raised for Mr. Gavino. In fact, Ms. Turnbull acknowledges the fact that my client was the party who took the kids to every medical appointment, started the counseling, looked into that, has been proactively seeking communications with the doctors up until when? Very recently, when again, dad knows on the verge of coming to court. Well, I'm going to insert myself into this, although I have not been an active participant in years, contrary to his most recent declaration. He then states, well, clearly he makes a gigantic leap from, well, I don't know that my child's actually getting the Adderall, even though we've provided you previously several communications where the parties are addressing that. And I think that Madison is either taking it on her own or selling it. Well, that's a pretty significant leap. Again, we provided you a clean hair follicle test from my client. She states that didn't happen. The GAL says there's no evidence of that. And again, it gets down to the credibility of the matter. What he doesn't say is the thing that stands out. He doesn't address anything about his past drug use. And again, we've given you the text communications and the messages between him and his current wife, between him and his buddies, glorifying the rampant cocaine abuse, glorifying the alcohol abuse, talking about marijuana. Those have not been resolved. He doesn't say anything about that. He says, well, Judge, if you force me, I guess I won't use drugs anymore. I won't smoke marijuana, but oh, by the way, it's legal. It's still an addictive substance, just like alcohol or anything else. And this guy has a rich history. If you look at his hair follicle test from January and then again in February, there's pretty significant amounts in there. And as the GAL opines in her report, this is an untreated issue with him. And again, how's this impacting the kids? The fact that he doesn't acknowledge it, the fact he says, well, it's only kind of limited me in my past. Well, it's kind of overstated. I don't really have a problem. Well, if you make me quit, I will. Again, those are all the types of examples and excuses and responses we get from somebody who's addicted to a substance. And clearly the denial and the fact that he doesn't come forward to this court with clean hands and acknowledge that at any time is concerning, especially concerning the fact that we're here on a GAL review hearing and he still issues a declaration that says, well, I'll stop if you make me. What does his current wife say? His current wife gives information that states, well, he's kind of a cycle user. He'll go long periods of time where he doesn't need to do anything, but then he'll drink and he'll smoke a lot of pot. What does my client tell you? This guy smokes a lot of pot. Now, this is a guy who has impacted his past job performance. And this is a guy who, again, in his own words to his buddies and his romantic partners and prostitutes, is glorifying this usage. That's all problematic. So again, the fact that we have this information and he continues to deny that, again, comes down to what? The credibility. And this court specifically appointed a GAL to get to the crux of who is more candid, who is telling the truth, and what the impact is on the kids. And I can only surmise at this point, we know what that is. It's interesting to note that counsel states that the parties just want a stability for these kids. And what does Mr. Gavino do? Well, he's right in the process of moving and doesn't give anybody notice of that. He just up and moves. Again, from somewhere, I believe in St. Helens or the like, now back to Kelso. We still have not been provided with that address. We still don't know. That's not stability. That's frequent moves. The fact that the kids have witnessed what they have, the fact that there's absolutely no oversight in dad's home, the fact that he is now going behind everyone's back and making medical appointments, meeting with counselors when he's had zero interest in that over the last several years since the separation, again, is very concerning. That's the sign of somebody who has not gotten over the domestic violence issues and the control issues that have been prevalent throughout this matter. And again, you take all of that, you wind all of that up, everything he's been pinpointing that my client may be doing and could be doing based purely on his own speculation and hearsay is not borne out by the GAL report. There is no findings about that. In fact, the findings are contrary to everything that's been put forth today and previously. Today, and in the declarations, is nothing more than reciting what the court already has heard from him on 3 prior occasions, and largely what is not borne out by the GAL investigation. We're here today asking that you do modify the parenting plan. We're here today asking that you do award my client primary custody and adopt what we had proposed a couple of weeks ago. Once we did receive that GAL report, we absolutely believe that is in the kids' best interest. We absolutely believe that there needs to be some consideration for sole decision making to my client when it comes to these extracurricular activities, the medical decisions and the like, because right now we have Mr. Gavino who's just running roughshod over the entire process and doing whatever he feels like. Again, not to meet the best interest of the kids, but to win at all costs in a parenting plan modification. That is not good for these kids. They need some structure and consistency, the same type that they've had. And that is by, in our opinion, adopting the proposed parenting plan that we provided in anticipation of today. I could go on and on. I'm not going to, and I apologize. I know that was long. We could continue talking about this probably all day. We need to get to trial on this. We need to have testimony on this. But on an interim basis, these kids are struggling, and we would certainly assume it's a lot of what's going on at dad's house.
Thank you. All right. So I appreciate everybody's input. Appreciate Ms. Turnbull's report and investigation. The 3 issues, the big concerns, there was the domestic violence in the mother's home, the pornography, the Adderall, and then issues that tie into each of those things. What I think is important, I'll just talk about the mother's domestic violence. The broken picker comment, it's an interesting phrase, and some people are attracted to folks that are maybe more problematic in their lives. So I think it's really important that the mother get involved in domestic violence counseling and personal counseling. That may be through one provider, but it could be through 2, and I'm not sure. But I think the domestic violence component is very important, and that addresses the broken picker comment that was raised. Because obviously the past violence in the home was very concerning, and the individuals that were brought into the home were very concerning. I think a 9-month moratorium from today's date moving forward on any romantic interest and relationships should be sternly enforced, and that will allow some time for growth and reflection and possible hopeful change. I also think, as far as the domestic violence evaluation for Mr. Gavino, I think that's important also. I think the broken picker, one could make a fair argument that the broken picker applies to Mr. Gavino also. He's had kind of a troubled past with alcohol and illicit relationships with other women. And there's evidence of concerns related to his past activities, even though I recognize in a prior parenting plan there were no issues found. I think with the guardian ad litem report that those have unearthed some issues. So I think a domestic violence evaluation for Mr. Gavino is appropriate, and any recommended treatment he should follow up and do. So I think that's important. I think it's also important related to the Adderall. There's much swirling about with the Adderall and the like, and a lot of information. I think at this point, the Adderall has ceased, and there's a lot of reasons why people may be prescribed it or not prescribed it. I guess just the one item as far as like medical decisions, it's going to be joint medical decision making. And if prescriptions are prescribed by a prescriber, then both parents are on the hook to provide that to the child. If there's not, then there's no issues to address necessarily. So with the father's use, he indicated, I read in the pleadings that he indicated that he had not used THC or consumed THC since sometime in November of last year. Apparently he does use on a regular basis, because the January and February testing showed that he had consumed marijuana. So I think it's that there's a restriction be placed on the father that he not consume any mind-altering substances, including alcohol or marijuana or any other mind-altering substances 12 hours prior to or during the residential time with the children. I think that's important. I think also an SUD evaluation for the father is ripe, and that he should undergo that. If there's no issues, great. If there are issues, then the children hopefully will be benefited by any improvements he can make in his life. And I think a hair follicle testing by the mother of the father, and also UA requests are appropriate also. And she can make those requests, prepay those if she comes back that it's clean. And I recognize with the marijuana, we would have to take a look at that kind of on a longitudinal basis to see if levels are increasing or decreasing. So recognizing that marijuana will stay in the system, as far as payment on that, she just has to eat that cost, and he would likely be positive, but we would be taking a look. If it's increased the next time, then he would be on the hook for payment of those repayment of the testing cost. The issue of the pornography, I think there's plenty of blame to share. I think with children nowadays, it's a matter of if. It's not a matter of when. It's a matter of, well, it's going to happen. That's what I was trying to say. It's going to happen, and it's happening at younger and younger ages. And I think sometimes that surprises parents, like, holy smokes, 8-year-olds have access. Okay, and it happens, then everybody panics, and there's great concern, rightfully so. Their minds and their psyches just aren't ready for that. So I think hopefully at this point, everybody's kind of put on notice, and I do think that it is important that that all parties have restrictions on the electronic passwords, computer be an open view or a door open, and that those restrictions be in place when the children are using electronics. I do still want to have sight and sound supervision when Landon is near the children. I think that's appropriate. He's a young man also. He may not have felt the significant impact of what happened. So I think the sight and sound supervision of Landon when he's with the other children is important, and I'll require that. With regard to the decision making, I'm going to order joint decision making for health. And I recognize that it sounds like Ms. Cook has been kind of the primary steady provider of those services, where Mr. Gavino is maybe coming a little more late to the game to that, but he's expressing interest in following through with that. So I think that's a positive thing. And so it'll be a joint decision making for health. Extracurricular, I think there's some concerns shown there. And I think kind of the steadiness of the mother in the past of being kind of the steady decision maker. I'm going to grant sole decision making for extracurricular activities to the mother. For school, it'll be joint decision making for both. With regard to the request to change the parenting plan to a primary of one parent or the other with lesser visitation for the other, I'm going to hold off on that. I'm going to hold off and leave it as a 50-50 plan because of hopefully the protections and the evaluations and the change in growth that is hoped for through those evaluations and treatments and counseling. So I'm not going to make a change to the parenting plan. The parties can go to trial and present information to the court, and the court can make a decision after hearing more fully and widely about any particular issues. But at this point, the parenting plan is not going to change other than those things that I've mentioned here today.
So just a couple of clarifications, Judge, on the evaluations. Are those with input of my client and the GAL?
Yes.
And do we want the domestic violence evaluation to be done locally with Olivia Lovely?
So I'm going to object only that I think my client already has one in process. And so I don't want him to then be in a position where he has to double pay. They should be, I would agree that they should be a Washington State certified provider.
Yeah, I have a little hesitation of singling out a particular provider. It gives them an idea of like I'm providing some benefits, particularly to that provider. So I think it can be simply a Washington State certified domestic violence evaluator / provider. Other points of clarification.
Just presentation in 3 weeks.
I have some, Mr. Zandy. So on the hair follicle, we would ask that the court's restrictions on alcohol and drug use be as to both parties. So my client expressed concern. The hair follicle of the mother was clean, but it was provided quite a bit later after the petition was filed. As the court knows, it takes a minimum of essentially 3 to 4 weeks to even get to court. And then we have it provided quite some time later. So we'd ask that those prohibitions be as to both parties and the testing be as to both parties. Again, that sort of puts them on an equal playing field.
Okay. I'm gonna decline that invitation and just keep the prohibitions and restrictions focused on Mr. Gavino. I think there's a greater history that's been shown that's more concerning.
And then the second issue is regarding the court's made a decision to have sole decision making. We don't have any 191 findings that would indicate sole decision making. The second issue that is raised by that is that the only issue that was really addressed by mother was the child's, I think, basketball. The child has an eating disorder. So I would ask that if the court maintains sole decision making, even without a 191 finding, that there be an expedited review of any decisions like that. Because if one parent says, gee, I want him to play select basketball, and the other parent is like, I think that that's going to cause the child medical harm, we should have a quick way of resolving that so that one way or the other, the issue gets addressed by the court, but quickly, because sometimes those are quite time sensitive.
Okay.
Well, I would just suggest that if we're having joint medical decision-making, either parent could take that up with the doctor and say, hey, is playing basketball or bowling, which are two activities the kids have traditionally done, going to impact their health? And with the doctor, I'm sure would give sufficient input on that, as opposed to running in and bringing a motion. This case has already been expensive. We've already had a lot of litigation in this. I'd like to limit that to some extent. And I think that does it just by having the built-in joint for medical, if we go with the sole on extracurriculars.
It's a little challenging. I find physicians tend to write whatever you ask as far as those types of things that it's not a medical decision. And so physicians often, if you want a service animal, they'll write a script for that because there's no problem with their license in doing that. And so that kind of creates some oddities there. So again, I think it can cause concern.
Yeah, I don't agree that sometimes physicians become great advocates, and if a client asks for or patient asks for something, they're happy to provide that without a lot of thought. Is my impression sometimes. As far as the extracurricular, I'll keep that sole decision making to the mother, and there may be some messiness that will follow with joint decision making for health, but we'll deal with that as it comes.
Those are my only questions.
Ms. Turnbull, do you have any concerns, questions?
No, I'm just thinking that in terms of the younger child's eating disorder, I think that it is on the doctor to help monitor the child's eating disorder and weight. And if the extracurricular activities are contributing to a weight loss and an exacerbation of that, then, that's something that the parents and the doctor should be monitoring. So if that becomes a problem, then they can withdraw the child. But if it's not a problem, then the child can participate.
Yeah.
And they can work together to watch that.
Yep. And that's the hope that both parties will be working for the best interest. We'll set it to that date. Thank you.
And who do you want to draft that order? I guess counsel, I can flip a coin on that since.
No, this one's Mr. Zandy's. Because you were the one that pushed to have a hearing. So I think it's on Mr. Zandy on this one.
I'm happy to draft the order. I'll go ahead and do that.
Okay. I think you called heads, right, Mr. Zandy?
Heads it is.
Okay, great.
Take it.
All right. So we're here on, I believe, Ms. Williams' motion to amend the temporary family law order, which includes a parenting plan and attorney fees. There was a recent parenting plan that was entered on May 1st of this year, where it's mother's indicated as the primary custodial parent and the father enjoys residential time with the children or child Silas on every weekend, Saturday or Sunday for 4 hours on alternating weekends, and then Wednesday after school to 6 p.m. There was some new additional information provided from Olivia Lovely, and then also the counselor, Ms. Mansour, and that's the input that I've read. And so I think we're here to hear from the parties, and we'll hear from Ms. Jocelyn since your client is the moving party.
Thank you, Your Honor. Did you get these addendum from Ms. Lovely? It came in after our bench copies were sent.
Was that
So
the one that was dated April 13th?
Yes, so there's an original DV evaluation and an April 13th.
Yep, I reviewed both. Thank you.
Okay, thank you, Your Honor. So yes, I realize that we were just here several months ago, but the issue is the situation has continued to deteriorate, not only with Dustin's actions, but in terms of Silas's mental health. We started with the therapist, who the court is, I think, strongly looking at to sort of guide potential reunification and input. We have the therapist who recommends reducing visitation in terms of frequency and duration. And the reason she's recommending this is due to sort of the same nervous system dysregulation, which was happening before, the fact that Silas doesn't feel safe. And really what she has now brought up is that Silas's fears include his father's reaction, his fear of his father's inability to control his behaviors when he's upset, and repeating the abusive patterns. She believes that a decrease in time will give him the opportunity to focus on healing and eventually in the long run create that stronger connection. So what we did is we reached out to Mr. Williams's former counsel on March 14th and said, hey, look, here's a recommendation. She recommends reducing it to about an hour and a half a week. They refused, and the response was basically file whatever motions you want. And then they went on to state that my client has a right to see his son, which just further supports Dustin's sense of entitlement, which was brought up by Ms. Lovely, who did the DV evaluation. Dustin underwent a DV evaluation, one for the criminal case, but also Your Honor had ordered a DV evaluation in this matter. We were the ones who submitted both of these to the court. And Ms. Lovely, I think, is a well-respected individual and has some very key things to say. One of them was he lacks accountability for his actions. And this is all happening post the original motion. So she had indicated when Mr. Williams first came to her, Mr. Williams's reason why he was there is that he said, I love you on an iPad, but then later said it's a series of misunderstandings. Ms. Lovely was very clear that she recommended a 52-week program for domestic violence with up to 9 individual sessions, and also said that he could benefit from a parenting education program such as Children in Between, and a lengthier program such as active parenting. And she also stated she recommended he attend a parenting class specific to perpetrators of domestic violence. Then she further recommended supervised visitation with a state monitor. She wanted that to remain in effect until the therapist could start doing the reunification. And I think what's sort of key in her assessment is the things that all of the parties have said all along that Mr. Williams has continued to deny, is that her assessment, she noted that there was infliction of harm on a family member, the strangulation, abuse of children, the strangulation, the history of domestic violence with Sarah and threatening to kill her brother. And she also indicated Dustin lacks an overall accountability to the impact of his behavior. She indicates he presents as cavalier, minimizes how this impacts others. And I think what's very important is she goes, he doesn't present with a readiness to change. It doesn't appear that he wants to change, and that he has a sense of entitlement regarding access to his son and flagrantly disregarding the law. Again, she notes the second time he fails to take accountability. Now, when Dustin got that evaluation, he didn't like it. He showed up to his criminal court and said, I'm going to have her redo an evaluation because this information is just from Sarah. So Miss Lovely met with him again. Miss Lovely didn't change her recommendation. She again said a 52-week program and relisted all of the same factors as to what she reviewed. She also said that, you know what, if he's so adamant about, I didn't do any one of these things that have been supported by multiple people, that he should get a polygraph. And she says, that's not something I recommend that somebody do very often. And she also said one of her concerns was at no time has Dustin sought to validate or bring into consideration his son's views. He just dismisses them as roughhousing. And she said this is a significant concern in regards to his emotional well-being. And then again says his current therapist can provide the input, which she has. She also further went on to state that Dustin might be better served attending therapy with a panel of male therapists, such as A Better Way. So we've had several supervised visitations, and as prior and post last time we were here, there continues to be problems. On 3-4 with the professional monitor, Miss Stuffy, Dustin leans over, whispers to the son, "Hey, come to my house. I'll buy you a new snake and fish." And he's constantly trying to get Silas to come to his house. The monitor told him whispering was not an option, and if it happens again, the visit will stop, and your visit will then move to a controlled environment, an enclosed room. Then 4 days later, there was another visit that Miss Duffy supervised. Silas, a young child, wasn't acknowledging Dustin, and Dustin got irritated by this. Silas wrote a note and was like, "I want to go home." And then Dustin appeared, this is all per the monitor, appeared angry, started questioning her as if it was Miss Duffy's fault that Silas wanted to go home and didn't want to be there. He continued to badger her with questions. And then as they finally ended the visit, Dustin kept trying to get her attention, like, Miss Duffy, look at me, I'm hugging my son, trying to show like, hey, look, as opposed to he could have just hugged his son and be done. And then we have Dustin, now he's texting Miss Duffy and harassing her. On March 17th, we have a series of text messages where he's accusing her of playing games, accusing her of hassling him, and accusing her of making him out to be a bad parent. We have a 3/22 visit that was canceled due to Dustin saying, "I can't come, other people are sick." Dustin wasn't sick. Other people in his family were sick and couldn't attend the visit, so Dustin declined. And then 2 days ago, on Sunday, we had Ashley Folk supervise the visit. Same thing, trying to get Silas to come to the house. Silas says, "No, I don't want to go to the house." Dustin keeps saying, "Well, but you can see your fish," and all of these things. It was they also had an interaction where they were playing, I think, sort of like a hide and seek tag type of game. And when Dustin jumped out and, screamed as part of the game, the child started crying out of control. And my client truly believes that this is because of the fear that Silas still has of his father. And, another issue we have is during this 4-hour-long visit, Dustin didn't feed him. All the child got was ice cream at the end. And he was so starving that he ate 3 hamburgers at the end. So we have the therapist recommending a reduction. We have the evaluator who brings up serious concerns regarding Dustin. Dustin hasn't enrolled in any of the programs the evaluator recommends. He hasn't enrolled in any of the programs Your Honor ordered him to do. The vast majority, he had a very lengthy response, and the vast majority of his declaration had nothing to do with our motion, but to things prior to the parenting plan from last time, or things that happened in like 2009. I think the key things, though, that were brought up in Dustin's response was the CPS report and the police report. In the CPS report, Silas accounts the same thing that he's accounted to my client and his therapist, that his dad choked him, that he likes to hurt him, that he's a jerk, that he threw him on the bed, pushed by his neck and pinched him and he couldn't breathe. He tried to tell him. He was sitting on top of him. This child couldn't kick his legs. He started crying. His mouth felt weird and he saw bruises. This is everything that he's told to the police and my client therapist. And I think what's an interesting note is going through the CPS report, the CPS, when they asked the standard questions of involvement, had asked, is there a history of domestic violence? Dustin lied to CPS and said no. When in 2018, Dustin choked Sarah and she filed a protection order against him, and we provided the case number for Your Honor. The police report shows the same story that Silas said. And so our request is that Your Honor adopt the parenting plan that we have proposed today, cancel the review hearing, or at least cancel the current one and set one farther out, and order Dustin to pay $3,000 in attorney's fees and costs within 30 days for us having to file the motion and appear. Thank you.
Thank you, Ms. Jocelyn. Mr. Williams?
I'm here.
Very good. Thank you. What's your perspective, please?
Did you get a chance to read over my declaration?
I had a chance and I did read over your declaration. Yes.
Okay, so basically what I want to start with is Silas's mental health, and the decline has been basically with Miss Minsauer's therapy. And in the beginning, she recommended reunification therapy. And since then, right in the beginning, we've tried to reach out to Jennifer and Sarah to start the reunification counseling, because we could have had 3 or 4 months of reunification going, and haven't been able to do that because they're simply denying it. Jennifer has denied everything we've asked for. With the allegations about the choking, if you look at the police report, it says that there was no criminal intent. I've never been a criminal. I've never had any criminal charges aimed at me like that. So the fact that they want to keep going back to the fact that I choked Silas, you said yourself in the last court case that we had that you don't see a sense that I was cutting off his airway or had my hands around his throat. Silas even says that in the police report. So whatever Jennifer is going off of, that she says that I've choked him, that he got choked, that there's been a choking, a strangulation, none of that has happened in the police report. And the police report was 2 days after that incident. If there was an incident of choking or Silas was in fear, he could have went home that same day as when the incident happened. He had an iPad. He has a phone that he could have called Sarah. In the police report, it said Silas was calm. He did not appear nervous. He sat with his arms open and his knees apart. He didn't display any negative emotions and didn't seem upset. So for what I'm seeing is Jennifer and Sarah alienating me for the last months, not allowing me to talk to Silas, not allowing me to call him, not allowing anything, saying that I haven't done the evaluations. I've done the evaluations. I've done all the classes. I've done the 4-hour class. I'm in the other parenting class, the Incredible Years class. I'm going to enroll in the Children in Between class, and I think Sarah would benefit from that too. So and then the visit with the situation with Robin at the visit where she was saying that I was upset or when I came into the visit, Silas was ignoring me. That was not at all the case. When I came in, I just asked him what was up, how's it going, how are you, how was school, just basic questions that I always ask him every time because I don't get to see him very often. And prior to all of this stuff happening, Silas and I talked every single day, multiple times a day, probably 5, 6, 7 times a day. We talked. Like he would call me on his iPad or he would call me on his watch or whichever. And the visit with Robin, as we showed up, Silas obviously was not feeling well. You could tell something was wrong. And with him getting more and more upset and then deciding that he wanted to give Robin a note and say that he wanted to leave, he's never been forced to stay there or anything like that. And I asked Robin to come outside so that I could discuss with her away from Silas, because we have tried to keep all of this away from Silas so that he's not being coerced, so that he's not being manipulated, so he doesn't have to deal with any of what's going on. And I can't even ask him any questions as to how he feels or what's going on. So I asked Robin to come outside so I could talk to her while Silas kind of wound down a little bit, and they're misconstruing that as me forcing her or telling her to come outside with me, which was not the case. And the reason why I hugged Silas and told him that I loved him was because I wanted her to not accuse me of whispering to Silas about bringing him toys or snakes or any of that stuff. I've never whispered to him, and I've only said to him about coming to our house when all of this is done and he's ready to come back to our house. We can do those things, get a snake. We can talk about toys, talk about Xboxes and stuff like that. The text message to Robin was not accusing her of playing games, but Sarah of playing games and canceling and changing the visit times whenever it's convenient for Sarah and whatever party she has going on. The 322, me canceling the visit, was both my daughters had a stomach bug. One of them was in the hospital. It passed through our entire house. It wasn't that I wasn't able to come to see Silas or visit with Silas. It was I have to take care of my daughters, and I see them every single day. I take care of them every single day, just like a parent would. If I could, I would like to play a couple of recordings that I tried. I talked to the clerk, and she said that they don't accept like USB stuff. So I couldn't do the USB, like submit a USB, but I I have two audio recordings that I think are going to be pretty critical to just everything that's happening. And this is recordings that go back to the very beginning, to where this all started, before anything had happened, before said event that Silas supposedly got strangled or choked. I would like to play the audio if you are willing to listen to it. It's about 30 seconds.
I appreciate the invitation to listen to that. You indicated that this is a recording that was taken prior to any alleged roughhousing or strangulation related to Silas, correct?
No, it was just before the DVPO. It was just 3 days prior to Sarah filing the DVPO.
So earlier you said that it was prior to the recording was prior to the alleged strangulation. Now you're saying it's post the alleged strangulation?
No. Yes. I'm sorry. Yes, it is post strangulation, pre DVPO.
Yeah. Has Ms. Jocelyn heard the recording?
No, Your Honor.
Okay. So generally when we come to a hearing, all parties have had opportunity to review everything else that the other party is saying or presenting, and that's why everybody gets served copies with things. So without her being served a copy or being provided with that, I'll decline the invitation. You're certainly welcome to describe it.
And Your Honor, really briefly, Mr. Williams has somebody whispering to him during the court hearing, telling him what to say. I'm wondering if the court could instruct kindly.
Yeah, and Mr. Williams, you may not be aware of this, that when a party is representing themselves, they are representing themselves. And just like if we were in the court, if somebody's whispering in your ear, I wouldn't allow that. And so, yeah, I did hear that also, that what Ms. Jocelyn had indicated. So that would be improper for that to continue. And usually, the best practice is for people to turn their cameras on so I can see what's going on. And I know some people don't like that, but if it continues to be an issue, I'll require that. But I'm fine with it not requiring it at this point. So I'll decline the invitation to listen to that now, based on the lack of sharing that with the other side.
Okay, so you, if you read the declaration, then I basically described in text what the audio recording says, and it was me calling Sarah and starting a conversation with her, and her telling me that she has no idea what's going on. CPS was weird. Silas was fine. She doesn't know who would have called CPS, and she wasn't filing anything like CPS told her to. And the weekend looked good for Silas and I to go ride our dirt bikes.
Yeah, I read that.
That was 3 days before the DVPO. So I recorded that. And then also want to touch base a little bit about the fact that she's unreasonably denied every single supervisor that I've offered.
Tell me who the supervisors you offered, their names, please.
I offered Jessica White.
That's your girlfriend or companion?
That's my fiance, and we've been together now 5 years. So she's been in Silas's life 5 years.
Right.
She's done 5 Christmases, and
other names?
We have a daughter together, David Belt.
Okay.
Danielle.
And what's her relation?
That's Jessica's cousin.
Okay.
And Silas has known them for 4, 5, 6 years and gone to Christmases with them and multiple events and multiple Halloween events and fishing trips and
just need a list of the names, please.
Natasha White and then Kay White.
And those are related to Ms. Jessica?
Yes.
Okay. All right. Thanks. Go ahead.
And Sarah has personally herself dropped Silas off at Kay White's house. Has dropped him off at her house, waiting for us to show up. Sarah had a prior arrangement. She dropped Silas off with her, waiting to show up. And then.
And Your Honor, we're going to object to that. That's not in the moving paperwork. So my client hasn't had a chance to respond in terms of that is actually true or not.
The objection is noted. Go ahead, Mr. Williams. The objection is noted and sustained. Pardon me, Ms. Jocelyn.
And then, so as far as Miss Olivia showing or stating in her report that I don't have accountability, if I was not accountable, I wouldn't have gone to do the evals. I wouldn't take the classes. I wouldn't do everything that I'm doing right now, everything to try to go back to regular visits like we had before this has all started, before the allegations of me choking my son and kicking him and slapping him and all this stuff. So I want to go for reunification counseling as soon as we can. If we started reunification counseling like this week and we keep the May 16th hearing, that could be 3 to 4 weeks of reunification counseling going into the May 16th, and we could further evaluate that. I've already called A Better Way Counseling in Vancouver. I'm just waiting for them to get me onto their books. They're busy, so when you call them, you have to try to get in. And then I've also tried and set up reunification counseling with Charlotte Rosenvelt out of Longview, Washington. So I'm just trying to figure out what I can do on my end, and I'm doing everything I can to show them that I want to be in Silas's life. I want to be part of his life. I want to be part of his school life. I want to be part of all these events and stuff, which Sarah has not allowed me to be a part of since we divorced, since the beginning of our divorce, and the CPS interview was done on 12/8. The police report was done 9/15. I mean, how does Silas's mindset change in just 3 months, where he goes from, my dad's not a criminal, he meant to not hurt me, the police say I had no criminal intent, they don't see any criminal intent.
Your Honor, we're going to object. This assumes facts, not evidence. It's not what the police report or CPS reports.
Objections noted. I've read all the police reports and CPS reports. Go ahead.
Okay. I figured you had read them. So the fact that his mindset has changed somehow to, my dad's a jerk and I don't want to see my dad, but every weekend when we see him for 4 hours, he's happy. He has a great time. We don't whisper things to him. We do whatever Silas wants to do. If he wants to go have some ice cream, we have some ice cream. If he wants to go bowling, we go bowling. If he's hungry and wants 3 cheeseburgers, I would buy him 3 cheeseburgers. I would provide every single thing that he needs to be provided for at that moment. For Jennifer and Sarah to just slander my name and slander me and turn me into this criminal that kicked my son and has done all this and wasted the court's time and wasted all of our time. It's kind of weird to me that I'm getting accused of that, when every weekend Silas is saying, if in the declaration, you could see Silas is coming to us saying that my mom got me a brand new Xbox and it was $1,000, and I'm getting a brand new dirt bike and I'm getting all this stuff. So he's telling us all of this stuff that Sarah's buying him and coercing him into staying at her house or not wanting to go to dad's house because mom's house is really fun. And she has all these things that she can provide for him. So I'm just kind of at a loss as to where I need to go and what I need to do here from here on out, because I've done everything that I can do. I don't have counsel anymore because I can't afford it. I can't afford to pay $1,600 a month in supervised visits and then also pay my attorney, $1,200, $1,500, $1,800 just to read the documents that Sarah and her attorney are providing. So I don't make $10,000 a month. I also have a daughter, 2 daughters, and mortgages and bills on my end.
Okay.
I said, and why are we trying to eliminate my time like down to this when like the end result is to have more time and more reunification?
Right. Okay. Mr. Williams, thank you very much. I had a quick question, clarifying question for Ms. Jocelyn. What is the counselor's plan, Ms. Mansour's plan to rebuild the healthy connection between Dad and Silas? Do we know?
Not yet, Your Honor. I think the issue is we haven't even gotten to the point where Silas is ready to do that, because right now he's being forced into these 4-hour visits and the Wednesday visits, which is setting him back. It's not helping anything. And so she wants to, right now, my understanding is she wants to have the reduced visits for about an hour and a half a week, get him sort of stabilized, and then move into the fact. But I think before we get there, we have a lot of things that Mr. Williams needs to do.
Okay. All right. Thank you.
And we do have a couple quick reply, Your Honor.
I've got to move the docket along. I've read everything that the parties have reviewed. I took pretty copious notes, so I'm going to move forward. So we know from Ms. Olivia Lovely, she made an initial recommendation of 52 weeks, and that she took in additional information at the request of Mr. Williams, and she stands by the original recommendation, and indicated also that maybe a male counseling group may be a good fit for Mr. Williams, and also a polygraph would be appropriate if they so choose to utilize it. Important is kind of what we talked about before, is that, you know, I don't know what happened on the date of the alleged strangulation or harm caused to young Silas. What is coming through all the different pleadings and the comments from the parties and the other professionals is that there's maybe this the word attunement, being attuned to something, being attuned to Silas's needs. And you know, I think Mr. Williams hit it on the head in his declaration. He says, you know, Silas is a sensitive soul, and I think that's exactly right. So sensitive souls are different than non-sensitive souls. You can do things to non-sensitive souls that would not cause them any disturbance or any concern. You do the exact same thing to a sensitive soul, and it can cause deep rifts within that person's being and psyche. So that, I think that's kind of the issue that we're talking about here. I don't know what happened on the alleged date of the alleged allegation of strangulation. What I do know is that that there was some emotional damage caused to a sensitive soul by the name of Silas. And that Ms. Lovely indicates, you know, there's, you know, she uses the term strangulation and the like. There, you know, whether a strangulation or not, I don't know. The police didn't think it was worthy to move forward based on lack of criminal intent. CPS made an unfounded finding. What I do know is that there was some whether there was much physical harm, there probably wasn't. I mean, there was some marking apparently, but not of a significant nature. But I think that the psychological or emotional damage was not insignificant to Silas. And so therefore there's an opportunity to learn. And I think Mr. Williams is engaged in some of those classes, has completed at least one, he's registered for another. And there's an opportunity for a continued learning, because nobody comes to this earth with a lovely manual on how to be the perfect parent. So here, the Ms. Mansour, my main concern here is Silas's best interests. It's indicated from Ms. Mansour or Mansauer that she is clearly seeing fear about communicating with his father, about his feelings and thoughts. He's concerned about ability to control of his father, and also about concern about repeated abusive patterns. And those abusive patterns may not be physical; they may be kind of an emotional insensitivity that's there. So she does indicate that there's a clear interpersonal disconnection that needs to be rebuilt and revitalized. And that's why I'm concerned. I want to know what Ms. Mansour's plan is. I don't want to put this off a long time, because that's the issue that needs to be addressed, is that the connection, the relationship between father and son. There's some repair that needs to happen there. There's some changes. There's some sensitivity increases that need to occur, and the like. So the therapist who's seeing this child, I think on a weekly basis, I think it's on Wednesday mornings or something, according to the schedules, is recommending an hour and a half per week, which is a significant decrease in what Mr. Williams is currently enjoying with his son now. And she makes that recommendation because she wants to allow some time and space for healing. She says that there's a spike when the visitation is about to occur of kind of this emotional dysregulation and concerns of going to that and afterwards. And she also points to the need for a professional supervisor or a supervisor that would be appropriate for Silas. So what I want to see happen is that I need to see a written plan from Ms. Mansour of what her plan is, her specific plan to rebuild the connection between father, Mr. Williams, and his son, Silas, because right now it's strained. And the source of that, it could be a variety of sources. It could be a variety of inputs. And one of those variety of inputs is obviously the alleged strangulation. Something happened on that day, and maybe before, maybe after. I don't know exactly what happened, but there's something happened with that young man, and it's not sitting well with him, that needs to be addressed. So we'll come back on May 30th with the written report from Ms. Mansour, submitted well in advance of that date, probably at least 10 days prior, so that we can hear from her what her plan is to rebuild that healthy connection between father and son. Until then, I'm going to adopt partially the recommendation of Ms. Mansour, I'm going to reduce the visits to 2 hours per week with the same alternating Saturday, Sunday pattern that's been in the past. I'm eliminating the midweek, but it will be, like one Saturday, it'll be 2 hours. The next Sunday, it would be 2 hours, and so on. And so then we will review what the therapist has to say about a specific plan. And on the 30th of May, until that time, I'll finish and then you can ask a question. Until that time, then there'll need to be either a professional state licensed supervisor. The important part here is that it needs to be a neutral third party. And I don't have any issues necessarily with Jessica White being the supervisor. However, there's a clear connection to dad. There needs to be a party that doesn't have allegiance to the father, because it makes it more difficult to be a completely neutral in that situation. And the other proposed parties, there's an indication that there's concerns for criminal history and also kind of that connection, a little too close of a connection. So that's why I'm indicating that based on Ms. Mansour's input, that it be either a state licensed professional supervisor or somebody that has no allegiance, direct allegiance to Mr. Williams, and that could be the maternal grandparents, and also a person named Ashley. So those individuals can serve as those supervisors on that reduced timeframe status. Then I'm going to strike the May 16th date. We'll strike that date, and I'll get to your question in just a moment. The DV treatment, certainly, it sounds like Mr. Williams is making inroads to get that going. That's great. I'm denying the request for attorney fees, and that I am requiring the classes, the children in between of both parties, both mom and dad. I think that'll be helpful for Silas. And then it looks like he's completing the he's getting started the Incredible Years, did complete the 4-hour parenting class. So that's my ruling for today's hearing. I'll turn the time to the parties if you have any questions or clarification requests.
Yes, Your Honor, a couple of things. I know you said that father has been engaging in the DV treatment.
He has not. No, he has not. I recognize
Okay.
he's made inroads to make connections to a Better Way Counseling.
Okay, Your Honor, could you make it clear that father needs to provide us, because we haven't been provided anything to show that he has completed any class or enrolled in anything that you have recommended. So if you could make an order that fathers to provide us proof that he's talked to a Better Way, provide us proof that he's enrolled in the 52-week program or any other program you're ordering. And then I just wanted to clarify what classes you wanted my client to attend.
Okay, so Mr. Williams did supply a certificate that he did complete the 4-hour parenting class, so that's in the court file. As far as the domestic violence evaluation, the treatment, I think it's appropriate that Mr. Williams sign what's called an ROI, or release of information. So Ms. Jocelyn and her client can not necessarily peer into what's happening, but whether you're compliant or not. So you'll need to sign that. As far as the class that Ms. Williams needs to take, she needs to take the Children in Between class.
Thank you, Your Honor. And then just to clarify, we did see that Dad did take a parenting, but Miss Lovely wanted him to take a parenting class with a DV component. And so we don't see that. We also don't see anything that shows that he's enrolled in Incredible Years or Children in Between.
Yeah, Mr. Williams has indicated that he's registered, so he'll need to complete the Incredible Years class. And we're going to hold off on the specific parenting class with the DV component and allow the DV counselor to address any issues in the counseling. Mr. Williams.
Yes, Your Honor. I just wanted to, when you said the attuned to Silas, without just being able to call him or talk to him, how do I get more attuned to him? Because they've alienated me this entire time to be able to not talk to him about the situation or ask him how he feels or what he feels. And even during our visits on the weekends, I don't talk to him about it or ask him how he feels or anything like that. It's kind of been swept under the rug this entire time. And so with that, I will get Jennifer, I'll get Jennifer the stuff, any evaluations or any classes I enroll in, I will email those over to her. If I say anything to Silas though about the said incident, like if we're at a visit and I'm talking to him and I want to talk to him about it, they end the visits. They will end the visits. They'll just terminate them right away. We're not talking about that. But then how am I supposed to talk to him and get through it when Miss Mansauer already in her first report, she recommended reunification counseling start immediately. But
Okay.
this,
And we'll be back here on May 30th to address what what her recommendation, her specific plan is to make that happen.
well, what
So
about the, okay, Tim, thank you, Your Honor.
Oh, I sorry, I spoke over you. What did you say?
I mean, it's been 3 or 4 months that Sarah and Jennifer have basically alienated me from Silas's life and not allowed me to start reunification counseling, to do any of this stuff. And we never got any background reports back from any of the people that we asked to supervise the visits. And then you said yourself that it's sort of one-sided biased if it's like that. And how can Jennifer, or how can Jessica not supervise the visits, but it can be Sarah's friends and Sarah's mom and dad?
Yep, that's exactly right.
Okay.
That's exactly what I said. Yeah, it needs to be the allegiance part is the key part as far as the supervisor, because I'm trying to balance Silas's needs and him feeling comfortable and protected with the person who's doing the supervision being in a position where they can be objective to a degree. So if they see something that's happening, I want them to be able to intervene and not feel like there may be repercussions, or positive or negative, of how they monitor that. And then that's more likely to occur if they have a closer allegiance to you. So that's the reason for my ruling on that. So we need to get moving. I just want to make sure if there's any other questions related to the court's ruling here today.
You just said if she denied any, you said last in the visits, if she denies unreasonably, she will have to pay for the supervised visit.
Yep, that's true. And I made a finding here today that those names that you mentioned, that I asked you for the specific names of the individuals that you proposed. I'm making a finding that Ms. Williams did not unreasonably withhold agreement based on the lack of no allegiance, and also the criminal record concern. Okay. Hearing no other requests for clarification, we will review this. Ms. Mansour's input on May 30th at 9 o'clock. We've stricken the May 16th date. We'll see everybody then. Thank you.
Thank you.
Thank you.